this case has kind of been piecemealed a little bit. And I'm going to suggest that part of it has to do with Mr. Elliott being self-represented and trying to navigate his way through the civil legal process of what has been filed essentially as a negligence case or medical malpractice case against the defendants. A motion to dismiss was filed in this matter. We first had a scheduling on 4/24 of 26 for a hearing. The court heard some arguments, tried to kind of figure out the file, and there are a lot of moving parts simply because there have been so many cases filed and in various forums and trying to sort through exhibits and that kind of thing and duplicated materials. At any rate, I guess one of the points of reference with the current pending case that the defendants argue is basically a refiling of the same case, is the actual mandate in this matter. In case number 2023 CV 70, mandate was received by the Butler County District Court on April 14th of 2025 at 4:05 p.m. From the Court of Appeals. Publication number 127,044. And I'm not sure. I think petition for review by the Supreme Court was denied, but I'm not aware of anything that occurred after the mandate. And of course, the mandate's not issued if a petition for review is filed and accepted by the Supreme Court. So we have a mandate that concluded 23 CV 70, which is all the same or similar arguments that the plaintiff made in that case. And so I looked at that this morning again, read through that opinion. Mr. Elliott, have you read that opinion?
I believe I have it. I don't have it with me because I wasn't expecting to talk about that.
Well, you have to, because I can't defer or do anything different than what the Court of Appeals previously found in their case. There's no reason for me to rule otherwise or to send this case back to the Court of Appeals when they've already ruled on a lot of these matters. I'm not going to do that.
I disagree with the ruling.
Well, I imagine you do, but
well, because the whole case, this case and the 70 case, the 70 case was only ruled on a procedural bar because I failed to exhaust administrative remedies. And I've got the transcripts from the 70 case right here. And this was 6th day of June. And this is Mr. Wassinger's testimony. And he states, just the following on my motion to dismiss. Mr. Elliott has allegations related to an ankle injury or ankle surgery he had of March of 21. And he complains about the medical care and treatment that was provided since that ankle surgery. He did file a previous lawsuit. I'm going to skip to that and get to the important part. This is page 6 of those transcripts. His
hang on just a minute. Hang on. Slow down. I read the transcripts as well, but I want to make sure Lindsay, that you have the transcripts, and I assume you're talking about the transcripts from June 6th of 23 and May 10th of 23.
Yes.
Okay. Do you have those, counsel?
Your Honor, I do not have the transcripts, but I do have the opinion affirming in front of me and have reviewed it. And I'm
Okay.
prepared to discuss that as well as the rest of the procedural history of this case, on why you should dismiss the case.
Okay. So, Mr. Elliott, where you're reading from, direct me to that. Amy, do you happen to have these transcripts somewhere electronically that you can forward to defense counsel?
Were they filed in the 23 CV 70 case?
Yes.
Okay.
So she can maybe pull that up.
I don't know that she'll be able to pull the actual transcripts because they're filed as sealed.
Okay.
Let me see if I can find them and I will forward them over to counsel.
Okay. All right, I am going to take judicial notice of the mandate and the Court of Appeals opinion that I referred to, and make it part of the record in this hearing, in this case, which was filed on April 14th of 2025. I've already made reference to it. It is an unpublished opinion. I'm going to take judicial notice of that. And I'm going to take judicial notice of the transcript of the motion to dismiss hearing from 2023-70. In 2025 CV 239, which is this case of May the 10th of 23, which was a hearing before me that has been transcribed, and June the 6th of 2023, which has been transcribed. So now they are part of the court record in this case for this hearing. And where are you referencing, Mr. Elliott?
The June 6th, 2023 transcripts, page 6.
Okay, I'm there.
Line 6 is the start of Mr. Wassinger's testimony.
Well, it's not testimony.
Well,
He's an attorney. It's statements. It's not
Okay.
testimony.
okay,
It's statements by an attorney, by
okay.
a litigant, a represented litigant. Go ahead.
If you go to line 23, it says his attachment on the entry form, there's a number of problems with it. First, it was filed way beyond the statute of limitations. That's set out in 4416-104A. The other thing is, it was never responded to by the El Dorado facility or by central office. So our position is that in this particular case, he has not exhausted his administrative remedies, and he would ask that this matter be dismissed. Okay, that's the state noting that I did file the injury claim. That's the state noting that the state, El Dorado and Central's office, refused to answer it because they know if it's not finalized, the courts have no recourse but to dismiss it for failure to exhaust administrative remedies, which is a procedural bar. Okay, now, in 2020 or in the 2025 case I just filed, I resubmitted that same exact injury claim form, and the staff at the facility answered it and denied it. Therefore, the procedure has been completed.
Okay, hang on. Okay, I'm following your argument. Hang on. Now, let's make note that I'm not sure how it came about. There was a question about whether or not your documents that you submitted in the 25 case were exhibits that had to be presented to court and admitted, or whether they were duplicates of the previous case, or whether they were legitimate materials to be filed. And what I told you at the last hearing was that basically I was going to consider these as exhibits to the petition to support your position that you can file a petition and that you have exhausted your administrative remedies and your statutory and the statutory requirement. So those now have been scanned and entered into the 2025 case and should be part of 2025 CV 239. Now, what I noted in what I have is your packet of information from that case filing is your July of 2023 when I sorted through the documents, your joint committee submission, and then you've always provided a lot of complaint forms for your medical. But I have identified here the joint committee, a July 28th of 23 letter to you that was denied. Your $200,000 claim was reviewed by the Legislative Research Department and denied. You followed up that there was a typographical error in an August 23 correspondence to them. Then there was a November 3rd of 23 letter that the claim was dismissed without prejudice. And then in looking at the remainder of the documents, let's see, I'm not seeing, point me, the form that you have to complete is the IMPP 01-118D, Roman numeral 1, capital D. And show me where you've provided that the Court of Appeals case clearly said as a litigant and as a self-represented litigant, whether it's in my court or in their court, you have to point to the documents specifically, and they have to be cited in the record as to what you're referring to. You can't just make a blanket general statement that I've done this, you've got that, I filed this. You have to point to the document so it can be marked as an exhibit so that they can review it on appeal if it goes to appeal. So point to me what form that you're talking about.
It's GG.
I don't see it individually marked, but
It should be.
it's your most important form that should have been marked as an exhibit and made part of your petition and reference. So tell me what it is.
It's exhibit GG. And all the documents that was cited there's exhibit FF, which is the joint committee claim. The one behind that should be exhibit GG, which is the injury claim originally filed and never answered, resubmitted in 2025, finally answered and submitted.
Okay, again, I see a bunch of stuff on grievances, which is what the Court of Appeals clearly addressed, is that there's no question that you've exhausted your administrative remedies on your 1501 and your grievances, but not to file a civil malpractice or negligence lawsuit. So,
So is the injury claim in there? Because there was 9 of them sent to the courts. The clerk notified me that I had to supply all 9 copies to them. I was going to mail them out individually. So I mailed in all 9 copies. The KDOC here took like 12 days to mail it. But there should be all the exhibits, including FF and GG. FF was the joint committee claim. GG was the original injury claim filed in 23, resubmitted in 25, and finally answered. If not, then I'll ask for a continuance. I'll get more copies and I'll mail them in because they were there.
well, they should be in order. And like I said, I've noted your legislative committee submissions. And when I went and read the mandate opinion, those were also admitted in that case and referenced and acknowledged by the Court of Appeals in that case.
Oh, yes, but when the Court of Appeals issued their mandate, the DOC had not answered the injury claim at that time. And that's why they procedurally barred
Right,
it for
right,
failure to exhaust.
right. And, you know, there's going to be a question whether that can occur after the fact, but even though, and argue that it was before the lawsuit, but I am still,
Okay, but in Mr.
hang on. Okay, then I've got a letter here from September 22nd of 23, which is your compliance with KAR 44-151023B, but we're talking about 4416A. And official grievance response, not there. Here's exhibit GG, attachment A, form 01118D001. Okay. So I am seeing exhibit GG and I'm going to admit it. I'm admitting as petitioner's exhibit 1 or court's exhibit 1, however you want to look at it, is, as I indicated, the mandate. Court exhibit 2 and 3 are the transcripts that have been referred to. And I'm going to refer to exhibit GG as an attachment to the petition dated July 2nd of 2025, submitted by Mr. Elliott. As in this hearing, plaintiffs or petitioners exhibit 1. All right. There is a response.
I don't mean to
dated-
interrupt you. I think you said exhibit 1 was the mandate.
No, those are court's exhibit. I can't
Okay.
make it an exhibit number of him when he hasn't marked and asked that it be admitted. So I'm referring
Understood.
to it as court's exhibit.
My bad. Sorry, Your Honor.
That's okay. And then, so GG is the letter. It's indicated as page 3 of 3. There's 1 of 3. I don't know. Where 2 of 3 is necessarily, but okay, 2 of 3 is your attachment A reference where you say, I need a full process response from the warden. Are you authorized to pay 200,000? Would you settle for 150? Any questions not answered will be considered a no. It was returned to the unit team. It was sent to the unit team, I assume, on 7/2 of 25. The form is they actually refer to it as IMPP 01-118 capital D. The form is filled out making a claim. You put a date of February 25th of 23 with your signature.
That
The
was the
back-
original.
Yeah, then the back of the form was not completed, so there was no acknowledgement of receipt. So there's no evidence that it was ever received. So you resubmitted it on July 8th of 24, or it was filed on July 1 of
Nope.
25. And then you received, I'm sorry, it was submitted on July 1 of 25. And then the Kansas Department of Corrections responded. I don't know how they could have responded July 8th of 24. That is obviously a typo. That should have been July 8th of 25. They can't respond to something you submitted before you ever submitted it.
I agree.
And they do acknowledge that they received the claim from the commencement of your date of injury, which has been pretty much referred to and established as your first surgery of March 11, 2021. And they denied it due to it not being timely filed. Okay, so now what we have, Ms. Barash, is in the record now is a response from the correctional facility, from the Department of Corrections. I don't know why it was signed by the senior administrative assistant and not the warden or an attorney, but whatever. I mean, I don't think there's any dispute that it's not a official response from them. And so now this GG has been made part of the record as Plaintiff's Exhibit 1. His argument, obviously, is that this was originally signed February 25th of 23, that it was notarized on February 28th of 23.
And that was Janelle Buchanan, who was a
Yeah,
unit
yeah.
team.
Right. The document speaks for itself. It was documented as received by unit team member Barry on 7/2/25 at 9:08 a.m. And there's nothing on the back. But now we have an official letter dated July 8th/24 that I believe should be 25, but I mean, I'm going to assume that for the record. That his claim of July 1/25 is being denied.
Can I clarify
And their
something?
reason for denial is it's out of time. Okay, so your argument, Ms. Barash, as it pertains to the record and the distinguishing factors that we've referenced, or I think I've referenced and admitted into this hearing for purposes of your motion to dismiss. If there are additional things, we can talk about those too, but let's stick with his argument that I submitted a form. It was never, well, I mean, you can argue it was never forwarded by him to anyone because there's never any evidence of receipt during that 2023 period. It's only evidence that it was notarized by someone. And I assume they didn't let him out of custody. So it's a state of Kansas notary. I assume it's someone within the Department of Corrections, which he claims is not his fault if it didn't get somewhere. And that he has now resubmitted it, that he has ongoing medical issues that he claims are correlated or related to the initial failures or lack of treatment, and that it has officially been denied by the Department of Corrections and the Legislative Committee. So that this is ripe, I'm going to use that word, ripe for filing today as of 2025 in 2025 CV 239.
Your Honor, may I proceed?
Yes.
I still believe defendants' argument that plaintiffs already litigated and lost the exhaustion through final appellate review. The Court of Appeals conclusively determined that plaintiff failed to exhaust his administrative remedies before filing the original lawsuit. He's now attempting to relitigate the same issue by attaching additional materials. The court noted these additional materials as Plaintiff's Exhibit 1, it's Exhibit GG. But even assuming Exhibit GG reflects later administrative activity, it still doesn't save plaintiff's claims here. After reviewing the exhibits, defendants acknowledge that Exhibit GG does contain additional materials that were not attached to the original petition. However, the dispositive issue here remains exactly the same, which is whether plaintiff properly exhausted administrative remedies before filing the original March 9th, 2023 lawsuit. And the Court of Appeals already answered that question and said no. The Court of Appeals specifically addressed plaintiff's reliance on the later joint committee proceedings. It expressly stated that filing a joint committee claim after the lawsuit was filed did not establish exhaustion before filing suit. And the court explained that the lawsuit was filed March 9, 2023. Plaintiff allegedly filed the joint committee claim July 1 of 23, and post-filing administrative activity could not establish post-exhaustion. And this is exactly what plaintiff is now attempting to rely on through Exhibit GG. So even assuming Exhibit GG contains additional administrative materials not included in the original petition, he's still attempting to litigate the same exhaustion issue arising from the same ankle treatment allegations. The question's not whether plaintiff now possesses additional paperwork, it's whether plaintiff may relitigate an exhaustion determination that was already conclusively decided through final appellate review. Just touching a little bit on KAR 4416-104A. We discussed that is the governing regulation. The Court of Appeals briefly touched on it in its ruling and recognized that the regulation requires submission of the personal injury claim within 10 calendar days of the claimed injury. Plaintiff's own allegations established he believed something was wrong throughout 2021 and 2022. There was an infection, drainage, MRSA, open wounds, and ongoing treatment complaints. But the IMPP claim form was not notarized until February of 2023. So even assuming plaintiff later pursued portions of the administrative process, the underlying administrative claim itself is untimely under KAR 4416-104A. And I want to note this for the court because the Court of Appeals declined to decide the timeliness issue because they didn't need to reach it. They concluded that the original case just failed on exhaustion grounds and they didn't need to get to that point. But that issue remains available for this court's determination. I do want to briefly note that to the extent the original form wasn't responded to in the proper time, that form was incomplete. I believe that was part of the court's original holding in the first case that the plaintiff did not finalize the form within the 10-day window that he had to do so, and it was incomplete. And that was a factor that the court relied upon in its ruling. So I still believe that this case is barred by claim preclusion and res judicata, both of the two, and that the saving statute doesn't rescue this claim. I do want to note for the court, I'm not positive whether the filing fee has been paid in this case as well. I didn't see any note of that.
Well, if it hasn't, I'm going to order that it is. He's always represented that he has funds sufficient to pay for things. So there's a minimum $3 filing fee, even if he's indigent. And I don't know what he has in his inmate account. So I understand. I'll let you reserve that issue. But for now, I'm going to focus on these substantive issues that we're addressing. All right. Well, here's what I'm going to do. And I apologize to you.
I would like to comment on her
No,
statement.
I'm gonna have you wait. I'm gonna have you wait, please. I'm sorry, but because there was an error in notification to the facility of your hearing and it started at 9:30, I am short on time because I had you scheduled for an hour starting at 9 to 10, and it's 10:03, and I have another civil case, another motion to dismiss, and those folks are going to be waiting for me. So I'm not trying to be rude to you, Mr. Elliott. You aren't going anywhere for a while, and I'm not dismissing this case today, okay? But here's what I am going to do, and you can put together your thoughts and write them all down on what your response to her statements to the court this morning, and I'll give you a chance to do that at our next hearing. But this is what I want briefed by counsel and Mr. Elliott, and I'm going to give you a deadline to do that. So what I want to rule on is whether or not under the, I mean, you can further argue the saving clause if you want to as part of your brief, but and cite any case law that you might have. But I want a brief on the continuing violation doctrine and whether or not it applies or should apply to this case. And let's assume, and I want to see any case law on submission of any kind of grievance that doesn't show receipt. I think there's some case law out there, and I need to refresh my memory. If for 1501s, let's say, if an inmate hands an employee a document that they want filed, but it doesn't get to the clerk of the district court until 5 weeks later. It's acknowledged that, that filing occurs when a representative of the facility receives some documents, because we all have to concede that inmates don't have the ability to walk out of their cells and come to the courthouse and file documents. And nothing can be, you know, taken from an inmate and put under the rug and then, you know, claim that it wasn't filed or procedure wasn't filed. That's, and I'm not trying to find any gotcha moments either, just like the Court of Appeals wasn't. But I think the only issue that I have, which could possibly salvage your claim, Mr. Elliott, is a finding, some kind of constructive finding as it relates to your original claim in February of 23, even though it was not initialed by or responded to by the facility, and that you have an ongoing injury, and not an incident, so not an accident or something that was a clear date of injury, but an ongoing medical issue that would be possibly consistent with the continuing violation doctrine if it was recognized in the state of Kansas. I have to look back. I'm not sure it was recognized by the 10th Circuit, but I'm not sure. And then additional argument that even if there's no constructive finding of receipt and a failure to respond by the facility back on February 25th, 28th of 23, can your resubmission, based on the fact that the previous lawsuit was dismissed without prejudice, can your resubmission and their response of July 8, 2025 save your exhaustion claim, and that it would be timely as well because you continue to have these issues that you filed grievances on at a number of about 32 plus grievances. Now, one other thing for the record, when Mr. Elliott, was the last time that you filed a medical form related to your original foot injury? Okay, well, we're done then for today. All right.
I put one in this year, in which I told you about on the last Zoom hearing.
I don't care when you told me. It has to be made part of the record today. I'm asking you today. I'm not going to fight with you about your case or your cases. I'm trying to make a good record for you today. And pouting isn't going to get you there. So
well, when I want to
was
clarify
for
stuff,
the
you
record-
always deny me that.
well, when was the last, when did you make I want you to submit the most recent claim that you made this year, medical claim, as part of the record in this case. All right?
Pertaining to my foot.
Yes. It has to be consistent presentation of complaints that you made from day one. Okay?
So a minute ago, you stated that I filed 23 grievances, and that was incorrect. I have put in over 35 sick calls.
I said 32 plus.
Okay,
But
but
I
you said
thought
grievances. They weren't grievances, they were sick calls.
That's what I meant.
Okay, that's,
They kind of were, a grievance in that they were continued sick calls of the same complaints that weren't being addressed. But okay, let's term them properly. Sick calls. All right. I need your last sick call that you filed with the facility to make it part of this record.
Okay.
And I need your brief. All right, so counsel, I'm gonna ask you to file your brief if you can by June 19th is a holiday. Can you do June 22nd or June 26th?
Yes, Your Honor, whatever the court desires.
I'm gonna give you June 26th as a deadline. And then I'm gonna allow Mr. Elliott to respond to your brief, and I'm going to give him 2 weeks. Now, Mr. Elliott, you can start putting together, you know what issue I'm asking you to address. You can start putting your stuff together today. But I will give you additional time after she files her to add anything and to address any argument that she makes. So I want your brief or legal memorandum, whatever you want to call it, to be filed by July 10th. And then I'm going to have a hearing on this on July 17th at 11 o'clock, if that works for you, counsel.
It should. Give me one moment.
You said July 17th?
Yes.
That works for me, Your Honor.
Okay. We'll do the notice. It'll be set for an hour. Ms. Barash, I'm sure you're aware the facility doesn't like anything during lunch or any time after generally 2 o'clock when they do shift changes. And so that really limits us to the mornings. And I have,
The whole day is free for me, Your Honor, whatever
Okay,
works
good.
best for the court.
okay, I have a 9 and a 10 o'clock. So that's why I'm setting this at 11. All right, are we all clear on what the court's requesting? And again, we're piecemealing this hearing, but I think that's okay. At least that's the way I have to do it too. Make sure, in all fairness, that I am reviewing things and that I'm making a good record. And I know there are lots of things that could be argued or stated, but I'm trying to keep this pinpointed to the bare minimum, based on the Court of Appeals previous opinion, because I can't relitigate. I mean, I'm not going to redecide what they've already ruled on, but I think I've made clear what I'm still looking at, and I've not dismissed the case, and I need